Hello, this is Dennis Kavanagh, and this is a video about powers of arrest and the law around that, intended for the people over at Mumsnet who asked me just to talk about this subject. So I'm going to try and do a sort of whistle-stop tour through the law in this area and deal with some of the practical matters that have cropped up recently. I'm for anyone that's interested or needs to correct me, I'm taking the law from Blackstone's Criminal Practice 21. It hasn't changed too much. Obviously, this subject has cropped up as a result of what's been happening at various protests. And it's obviously becoming more and more important to understand what arrests are and how they work. So the first thing to say about an arrest in English and Welsh law is that an arrest itself is not defined in law under the statute that regulates this, which is the Police and Criminal Evidence Act of 1984. For our purposes, it is some interaction with a police officer that tells you that your liberty is affected. That is fundamentally what it is in law. Arrest in this country is primarily governed by Section 24 of the Police and Criminal Evidence Act of 1984. The heading for that section is arrest without a warrant. Obviously, courts can issue warrants for arrest if people don't turn up, or if a judge is presented with some reasoning for someone being arrested. But in the main, what we will see in protests, in fast-moving situations, are someone telling an officer something's happened and an arrest happening. So that's all governed by Section 24. How do we think about arrests? Well, an arrest has three parts, okay? It has grounds, it has reasons, and there must be necessity in order for it to be lawful, all right? If it fails on any of those three grounds, you may have a situation where the arrest is liable to challenge. That is to say, you can take a civil case out and say, I want some money from the police because I was unlawfully arrested. I mean, one hopes that you don't end up in that situation in the first place, but that's the consequence of one of the trifecta being missing. So in order just to consider those, I'd like to go to the section itself available online. There it is, good old Police and Criminal Evidence Act. So as we know, we've got grounds, we've got reasons, and we've got necessity. Now, you can see that grounds are basically up here, all right? It's really straightforward. A constable can arrest someone, and then it's just past, present, future. If they have committed an offence, if they're going to commit an offence, or if they have reasonable grounds for suspecting they're about to commit an offence. Now, let's just take the the protest example. In a protest example, you would be dealing with the past, wouldn't you? So it would be subsection 2, an offence has been committed. And let's just focus on that for a moment. In order to judge whether someone should be arrested, whether you have grounds for an arrest, an officer must have, quote, reasonable suspicion, all right? Now, reasonable suspicion in case law, there are two dimensions to it. Reasonable suspicion means this. It means that the officer themselves must have a reasonable suspicion that you've committed an offence. And the law also says that it should also mean, so that's subjective, the particular officer, but it also means that a hypothetical officer with the same information would also have reasonable suspicion. That's what it means, all right? Now, objective test is there just so we can keep the police accountable. That's what it means. Now, there's a third layer to this, which is that it must be what we would call Wednesbury reasonable. Don't worry too much about that. Wednesbury unreasonable simply means a decision so unreasonable no one faced with those facts could make that decision. It means way out, all right? So on subsection 2, if an officer is going to arrest someone, they must have reasonable suspicion, just to recap, that the person's committed an offence. Any hypothetical officer in their shoes must also, hypothetically, have reasonable suspicion. And both of those views, as it were, they must be reasonable. They must be views that reasonable people could come to. Okay, so that's how that works. Those are grounds. All right. Now, in addition to grounds, there must be reasons, and the reasons are set out in subsection 5 here. So it's to get someone's name. Please watch for that. If you don't provide police officers your name, that you can be arrested if there are grounds as well. And you can see also that goes for address. You can also have as a reason for arrest if someone's going to injure themselves, injure other people, causing damage to property, all the things you would expect. You know, the police obviously need those powers. But the one that you're going to see most in protests is a new one. Well, relatively new. I mean, it's been there a few years now, and it's prompt and effective investigation. So what you normally hear with a protest is, I'm arresting you for a Public Order Act offence. You are under arrest for, I don't know, Section 4 Public Order Act. The reason for the arrest is to allow the prompt and effective investigation of the offence. So grounds, reasons, and I haven't covered it yet, but finally we've got necessity. All right. Now, necessity is important in arrest because in order for an arrest to be lawful, there it is. Sorry, I lost it for a moment there. There it is in subsection 4. It's got to be necessary to arrest you. Now, necessity is important because, and it's important in protests, and it's important in cases like we've had recently about challenging people for using the ladies' loos. We've also had it crop up with some gay guys being arrested at protests for various bits and pieces. Right, so just to quote Blackstone's on this, in addition to the conditions set out in section 24, which we just covered, the officer must have reasonable grounds, so there's that phrase again, for believing the arrest is necessary for any of the reasons set out. So we just had a reason, didn't we? Prompt and effective. Necessity cannot be regarded as a synonym for desirable or convenient. And I think that's important. That's really important in these protest situations. And that comes from a case called RTL and the Chief Constable of Surrey Police, and there's a Metropolitan Police case there as well. So you see then that in order for arrest to be lawful, grounds, reasons, necessity. Okay. Now, this ties in with another provision that we should look at, which is the use of force, because an arrest will ordinarily involve the use of some force. And that is governed by section 117 of the Police and Criminal Evidence Act. We can see it's a very, very simple section. The important words are you can use reasonable force. Please note that if necessary, but it has to be in the exercise of the power. All right. So if the arrest is unlawful, the use of force would be unlawful. If force isn't necessary, the use of force will be unlawful. The arrest might not be, but the use of force would be. Now, I think that's quite important, particularly when we're talking about women being arrested in circumstances such as we have seen recently. What Blackstone says about use of force is this. It says, in determining what force is reasonable, the court may take into account all the circumstances, including the nature and degree of the force used, the gravity of the offence, the harm that would flow from the use of force against the subject, and the possibility of affecting the arrest or preventing the harm by other means. The fact that force results in serious injury doesn't necessarily make it unreasonable. That's the case of Roberts, which I think is a flying squad case, so don't worry about that. We're not so much talking about that. I go on, use of handcuffs. Quote, handcuffs should be used only where they are reasonably necessary to prevent an escape or prevent a violent breach of the peace by a prisoner. And the same rule applies to handcuffing of people. in courts. Quote, it would seem that where handcuffs are unjustifiably resorted to, their use will constitute a trespass, that's a trespass to the person, so like an assault, even though the arrest itself is lawful. All right, so those are the building blocks legally of what an arrest looks like. What I want to do now is just consider what this practically looks like in terms of some of the questions that have been asked. The first thing to say is this, going back to reasonable suspicion. You might be asking yourself, well, how does someone form reasonable suspicion? What are they allowed to look at? What aren't they allowed to look at? And the reality of the situation is that officers do frequently rely on what we would call hearsay. All that means is something that someone else has said. So if I go up to an officer, and you appreciate this happens every day, if I go up to an officer and say, over there, I've just seen that bloke stab another bloke, the officer didn't see it. So I have told the officer something that I want the officer to believe. That makes it hearsay, all right? Because the officer didn't see it. I saw it. And it would be strange, wouldn't it, if officers couldn't arrest on that basis. But as you see in protest situations, and as we have seen recently, it does open the door for those with nefarious intentions who are not telling the police the truth to get people arrested. And the police, as we can see here, are entitled and in fact must rely on hearsay evidence. What does that mean practically? I think it means this. I think it means one has to be tremendously careful about situations in which other people are given an opportunity to lie about you. So we had a chap, he's on Twitter, I think it's Adult Human Male, James is a gay bloke. He went to a protest outside Downing Street. He was there with, it was about the conversion therapy ban sort of time. He went there with a placard, which is like stop medicalizing kids, something like that, something the other side didn't like. Two people from the other side went up to an officer who wasn't looking at that area or him, told a pack of lies, said he's done this, that, and the other, and he was duly arrested, and ended up down a police station. Police released him ultimately because it was obvious, I think, to them eventually that they were not dealing with honest brokers, and he got his sign back after some argument. I'm not sure what the lawful basis of the police holding the sign would have been. It seems they didn't have one, but forgive me if this sounds really obvious, but the best advice is always have a witness. People are inhibited, or it's going to dent their ability to tell the police lies about you if you can say, look, I challenged this person in the ladies' loo, or I had this conversation, I don't know, one of these speaking events. I said this, they said that, I did this, they did that. Here is someone that can back me up. Equally, of course, one can take video recordings. I mean, you might not want to be doing that in the lays or anything like that, or one could take audio recordings. But I think you have to work on the basis in difficult situations that the other side do have a taste for using the police and lying to the police. So I do think you have to work on the basis that that is possible. And if at all possible, you should try to plan for it. And I say that fully appreciating that if you go into the ladies, you don't expect that. And I say that very much appreciating, particularly after conference, very much appreciating that protests can move very quickly. So sometimes, you want, as a lawyer particularly, you want to counsel perfection, and it's just not possible. But certainly, if one is in a situation, let's imagine that hasn't happened, that an officer says, I'm coming up to arrest you. I think the most important thing to say is that so far as you possibly can, you calmly and clearly state your case. You comply with all the lawful directions. So if you ask your name or address, you should give that. That's a power under the Police and Criminal Evidence Act, which we've just looked at. And just for reference, I think we saw it down in Reasons, didn't we? There we go. Reasons 5A and B. you should, so far as possible, try to communicate to the officer that what's going on here is not right, is not proper, is being engineered. But let me flip this around and say, well, what's the officer's duties if you are then arrested? Well, the law says that the officer must communicate two things to you. The first is that you are under arrest. So the officer must say, I'm arresting you. And normally they'll say, I'm arresting you for X, right? And the second thing they must communicate to you are the grounds for the arrest, all right? So where a person is arrested, whether or not for an offence, otherwise than being informed of being under arrest, I'm just reading for Blackstone's here, the arrest is unlawful unless the person is informed of being under arrest as soon as is practicable after the arrest. Forgive me one moment. I'm just going to stop sharing my screen just for one moment. Sorry about this. I just want to find a particular passage, so I'll pause for a second. Okay, it's just a couple of sentences on. It reads further, an arrest is unlawful unless the arrested person is informed of the grounds for the arrest at the time of the arrest or as soon after as is practicable. If the arrest is by a constable, which it normally will be, this applies even if the grounds of the arrest are obvious. The person must be informed why the arrest was believed to be necessary, although a failure to do so won't render the arrest unlawful. So that's just the communication of it. All right. So it's facts and grounds. In reality, officers will normally communicate facts, grounds, and reasons. So I'm arresting you for a public order offence. Grounds for that are someone just told me that you committed it. The reason is for the prompt and effective investigation of an offence. I should say that one thing that's quite interesting, and I think may crop up the more and more of these things happen, is that if someone is arrested and there is no chance whatsoever that they would ever be charged with an offence, so if it's just like a holding arrest, that arrest would be unlawful. All right. The question of investigating, the ifs, ands, and buts of that obviously are a slightly different topic. So just to recap, what you've got there then is the essence of the criminal law about what constitutes a lawful and an unlawful arrest. But the remedy for unlawful arrest is a civil action. Okay. So if I'm unlawfully arrested, what I do is I take out an action against the police. I think, as I say, more practically speaking, the better piece of advice is in fact the practical piece of advice, which is to look at the circumstances in which people have engineered other people being arrested and doing absolute level best to avoid them. Anyway, I hope that is of some assistance. It's a bit of a whistle-stop tour through it. I should say anything I say here, because I've largely been reading for Blackstone's, is subject to correction by minds more learned and better than my own. I'm happy to try to deal with questions in a thread, which I will put up in just a moment at the suggestion of some other people. I should also say arrest law, because it is quite old, and Blackstone's makes this comment, is quite well known for having cases that sort of go like that. It's such an old piece of law that if you do any reading into it, you will very likely find some authorities that go one way, some that go another. But what you've got there, broadly speaking, are the sort of trifecta of characteristics that make for a lawful arrest. Anyway, I hope that's been a useful mini law lecture. Very best of luck to everyone. Do take care of yourself if you're at these protests, because for my money, judging by conference, I think some of the other side are getting worse and worse. And yeah, I shall try to assist with queries as and when I can, when I get time on the thread. So take care, everyone, and I shall stop recording now. Bye-bye.